Is this Advocate Mahlangu appearing? I see Advocate Moratiwe is here. He's
my lady, my colleague and I have the same opponents, being Mr. Mahlangu and Mr. Masiki. They don't appear on the list here. I appear in 03.
Mm-hmm. Should we give him another 5 minutes?
As the court, please, my lady.
Because I'm not sure if somebody would have received a phone call as a courtesy. If you're late, I think that's the courteous thing to do, is to contact somebody involved in the matter and inform them, or even my secretary, and say I'm running late and I have a problem. But just to not connect, I think that's very unprofessional, I'm afraid.
As the court, please, Mali.
I will try to get hold of Mr. Mahlangu. I'm not sure why he has not connected yet. I'll just try. Okay.
No, I don't think you should. It's not your duty to do that.
Oh, okay.
It's his duty to contact you or to contact the court if he's late.
Yes.
So I would advise against you having to call him.
Not a problem.
Thank you for the offer, though.
As the court, please, my lady, perhaps your directions will be most welcome on whether when we should proceed in their absence or.
Well, it's a difficult situation because the practice note said all I'm dealing with today is this issue of the supplementary affidavit, not the hearing in total.
Yes, that will be correct, my lady. But similarly, on the second practice note, it had also no mention of the postponement is made. The practice note starting at page 5 of bundle 29.
Where do you get bundle 29?
It's on case lines, my lady. There is a second. There are two practice notes.
Disadvantage. I'm completely at a disadvantage. Durban, unfortunately, is not technologically as advanced as Gauteng. So we have no case lines. In fact, we don't even have Wi-Fi. And that is why I'm actually conducting this hearing from home.
As the court, please, my lady. Home is still caught, my lady. But I will then perhaps for the I don't know if copies had been sent to the registrar's office, my lady, but there is a second practice note which was filed more or less simultaneously with the other one, wherein it indicates.
I missed it because I would have thought it's the same thing.
Yes, that is a real possibility, my lady. So but perhaps I can read the practice note into the record, my lady.
Yeah, okay, do that.
In this practice note, it confirms that the matter is set down for hearing today. It confirms under paragraph 2 my appearance on behalf of the applicant, as well as Mr. Mahlangu on behalf of the respondents. It confirms that they will seek an order at 3, and the respondents seek a dismissal of the application. And it says under 4, facts or issues to be determined are the points in limine. Second, whether the requirements for the relief sought has been discharged. Third, whether the invoices submitted by the respondents were inflated as such unduly benefiting them. Fourth, whether the second respondent was correctly joined.
Then I don't have that. When did it come? We just hold on, let me see.
At the same time,
when it's sent to me, it's sent to me with a whole lot of trailing emails, so it's very difficult to get hold of. See, the ones
Yes.
that have just says no. Is the matter proceeding? No.
There should be another one, my lady. Where in at paragraph at point 7.
I don't have it.
Okay, there is a second one. It confirms that at point 7.1, it says the matter will proceed.
Mr. No, you're not listening to me. I said I don't have it.
You don't have it. Oh. My lady, that explains my endeavor to try and read this practice note, the respondent's practice note into the hearing. Perhaps Ms. Mashiti could assist on whether when she has received same or not.
Okay, thank you, Ms. Mashiti. I'm so used to calling her Ms. Info. It's so much easier for me. Can you please enlighten us? I'm looking at all the emails sent. The practice note. No.
My lady, perhaps also to assist. I see a Mr. Matlangu and Associates is waiting in the lobby to be accepted.
Okay.
Yes, they have been accepted. I think he should clarify himself. He is on record, my lady.
Okay. Okay. So now we need to, Mr. Matlangu?
Good morning, my lady.
What happened?
My lady?
I said, what happened? We were kept waiting.
Oh, my apologies, my lady. I had connected earlier at around 9 o'clock in the morning. When I tried to rejoin it about 10 to 10, it just went dead. So I had to try and reconnect again, my lady. And I apologize for that.
That's fine. I accept.
Thank you, my lady.
In now, you're acting in both the matters 03 and 04.
03 and 04, my lady.
Okay. Now we have a little problem. Mr. Mokonoto was enlightening me whilst you were getting online with regard to a practice directive that he sent saying that the whole matter was proceeding. I didn't receive that.
That's saying that the entire matter was proceeding, my lady. My lady, when I set my practice note, I indicated that we are going to raise a certain issue, which we, in our view, was contrary to what the case management meeting directive from Justice Mudipa away.
Is the matter proceeding? You had indicated no. That's the practice directive. All that I was asked to decide today is whether it's with regard to the filing of supplementary affidavits. That is all I was told. Now I'm told that the whole matter is proceeding.
Well, my lady, the whole matter cannot proceed for one simple reason. If my lady would permit me, with regards to the supplementary affidavits, specifically in this matter, your sister, Ladyship Mudipa, had indicated specifically that the applicants are not and should not file supplementary papers. That would appear in the minutes, in the case management minutes. However, when going through the case lines, documents filed in case line, I realized that the applicant had sneaked in a full supplementary affidavit, which goes contrary to what Justice Mudipa had directed in our case management meeting. That's putting the respondents at a disadvantaged position because now we are sitting with a case management directive that says no supplementary papers are permissible. However, the applicants continue and file a fully fledged supplementary affidavit, notwithstanding that they have not filed a request to file that affidavit.
And you haven't dealt with the contents of that either. Is that your concern?
No, I have not, my lady, because my problem is I'm sitting with a management outcome that says there ought not be a supplementary affidavit. Now, I don't know what to do with that because I would then be effectively condoning what the travesty that is committed by the applicants by filing their supplementary papers.
Okay, I hear you, and I see your difficulty. I had a similar difficulty when I read through the minutes of the meeting. But the way I understand it, what really occurred was the directive. It was a directive by the judge. It's not an order as such. I think it was during conduct of the pre-trial hearing, and I don't think the judge is bound by that, because the judge can always change her mind. It's just a directive. But the issue, I quite agree with you, is that you can't file the supplementary until you've at least obtained the leave of the court. And that places you in an invidious position, because you don't know how to deal with it, whether to deal with the contents of it or whether to oppose the application to file the supplementary. Am I right?
My lady, if I may assist the court, this was a case, all these cases are case managed, specifically for the simple reason that they are long outstanding. They had to move in a specific direction and speedily so. Now, the applicants made a request in that case management meeting to get permission for them to file supplementary papers, and that request was refused by Justice Moody, but to say that you are not permitted to file your supplementary papers because what you need to file essentially changes the tone of what you file in your founding papers, because essentially you are bringing in a new application, because you're saying that in your request, you're saying that your application is essentially incomplete without the supplementary affidavit. And the question that was asked specifically, why did you even come to court if your case was incomplete? And that request was specifically refused. They were actually denied, and they were told specifically not to file supplementary papers. So I understand your ladyship when she says that it's a directive, it's not a court order. However, as things have been done in the tribunal, it has always been that whatever directives are provided to us by the justices presiding in the tribunal, those are followed religiously, because for the reason was that we need to get to the end of these matters. And for you to then proceed and file papers when you are specifically prevented and told by a sitting judge that you are not allowed, in a case management meeting at that you are not allowed to file any supplementary papers, then you go and file supplementary papers, and you want to refer to them as something else but supplementary papers. So my difficulty is that what do I do then with the directive from the court? Do I ignore them completely and proceed as if those were never made by the court?
Mr. Mahlangu, I'm not sure if I'm correct. You know, I had to read a lot of documents in a short period of time. I subsequently saw another case management meeting. Was it in August or October, where the judge indicated that an application should then be made to file the supplementary affidavit?
Yes.
So that seems to suggest to me that the judge revisited her previous, I wouldn't call it an order, a previous ruling that there should be not. So in other words, he reconsidered and said, well, bring the formal application to file the supplementary. So it seems that it's not completely correct to say that she closed the door entirely on the filing of further affidavit. Filing a supplementary affidavit.
If I may be permitted to assist, my lady, what your ladyship is referring to is a different matter. The matter wherein my colleague Advocate Moretla is appearing in. In that matter, the judge had directed, we were sitting in a case and the judge had said, if you want to file supplementary papers, you need to lodge an application for that purpose. But in this matter that your ladyship is seized with now, they were specifically barred and they were specifically informed that they must not file supplementary papers. Their request was refused, my lady. What your ladyship is referring to is a matter where I appear with Advocate Moretla.
Okay. I think it's because I've been reading them simultaneously. They're both almost identical. Okay, let's just look at what was the last practice directive. Can you refer me to the page in my file? You see, my file is been, whoever's prepared this file has not numbered it. Is it properly numbered? Oh, I see on the top, the red numbers. Okay. Can somebody direct me to the page on which the last practice directive or the only practice directive let's see, answering affidavit.
If I may assist, my lady, that would be bundle 000. It's starting at page 1. So it would be at the top of your pages, you will have 000-1. That is the court order dated 4 October 2022.
I don't know how this 000.
At the top of the page on the right-hand side, Her Ladyship will find the pages are marked in red, I hope, if it were not printed on a color print. And yes, so you will have the pages that start with 000, 000-1, and then it will be pages 1 to 3. The same numbering appears even at the bottom of each and every page, Malid.
Okay, my 0001.
Yes.
I haven't got 000. I've got a 001. And it's the notice of motion. So I'm not sure where I'm going to find a 000.
There should be a 000.
It says court order 000, but it's how do I get to this 14? Is that how I read this? See, I don't know how to work this index. It just doesn't work with me. See now, it says you have 14, under 14, court order dated 4th of October. It's 0001. But now mine is not consecutively numbered. So I don't know. Whoever compiles this it really hasn't done their work properly, because it doesn't help me, because I don't have case line. So now I have to, I don't know. Where do I find 000? Okay. I'm looking, it's just, I can't find it easily. There has to be a change in the method. I think we must go to the conventional method of numbering papers as 1 to whatever, and have the index accordingly in future. That makes it, okay, let's see what the order says. Which one are we dealing with, Mr. Moroto?
We are dealing 004.
Right. Now 004.
I'm sorry, NW04 of
It
2020.
says, yes, this is what I read. So,
Yes.
right.
My lady,
Hold on, I'm still busy. Mr. Moroto, it says very clearly, the matter is hereby postponed to the 1st of March for hearing. The further conduct of this matter shall be as follows. By 7 October, the applicants shall seek leave to file the supplementary affidavit. That is exactly what I've been telling Advocate Mahlangu. That's what I read.
that is correct, my lady.
So, Advocate Mahlangu, you clearly don't have this document. I have it here signed by Judge Modiba. So I was correct in what I said.
You are correct. I think he's muted and we can't hear what he's saying, but you are correct, my lady.
I'm not muted. Am I muted?
No, my lady. Mr. Mahlangu is muted.
Muted. No, he's muted. Okay, here you are. Mr. Mahlangu, I think I have the document. I was correct. I think you are muted, Mr. Mahlangu, and I've lost your visuals as well.
No, I can see Judge and I can hear Judge. I can see both Judge and Mr. Mukonoto, yes. I don't know whether I'm audible and visible, my lady.
Now you're audible, yes.
Thank you, my lady. If your ladyship could be so kind as to take me through the part where the judge made an order insofar as the supplementary papers are concerned, my lady.
Okay. At first, I looked at the case number. It's NW04. Parties are MP2 and Special Investigating Unit. It says here on page 0002, this matter is hereby postponed to the 1st of March, 2023 for hearing. The further conduct of this matter shall be as follows. By 7 October, the applicants shall seek leave to file their supplementary affidavit 2, the respondents shall answer to the applicant's request for leave to file a supplementary affidavit by the 21st of October. The applicants shall file a replying affidavit by the 4th of November, and the applicants shall file supplementary heads of argument by the 18th of November, and the respondents shall file supplementary heads of argument by the 25th of November. 3, the applicants shall pay the respondents' wasted costs for 4 October 22 on a party and party scale. So that was correct.
Yes, I think I confused that. I think your ladyship was correct. I confused the two matters, my lady. I think your ladyship was correct, and for that I apologize. I was not intending to mislead your ladyship.
That's fine. That's fine. As I said to you, I was confused myself because I was reading both almost simultaneously. So I think I can understand that. So we have this situation where it seems that she revisited that, and then the real application today is whether the supplementary affidavit should be filed. Clearly, we can't proceed with the whole hearing because depending on my ruling on whether that supplementary affidavit should be filed, you may wish to file a further further affidavit. Is that right, Mr. Mahlangu?
My lady, you see, my understanding is that they ought to have sought permission first to file the application. Then I would respond to that request. Then if that request was granted, then we'll move on to the supplementary affidavit and my answer there too. But since they have not done that, they went straight to file their supplementary affidavit. It creates a precarious position for all involved, in the sense that now we are at the later stage of the matter without having dealt with the preliminary issues.
So I seem to recall they said somewhere that they're seeking leave to file the supplementary affidavit.
I've gone through their notice of motion. It does not say that, my lady.
So they didn't bring the application, a formal application to file.
They never filed a substantial. They merely say in their notice of motion that they request that the attached supplementary affidavit be incorporated rather into the main application and be dealt with as the main application. That in itself is not an application for permission.
And the order of the court was very specific that they shall seek leave to file the supplementary affidavit. Okay.
That is accurate, my lady.
Thank you. Mr. Mokonoto?
May it please you, my lady. My lady, if I could refer you to bundle 011.
Yo, I don't have it in that form. Yeah.
Marked in red 011.
No, I don't know how to find that here. It's really, really difficult. I don't know who compiles these, but the instructing attorney, whoever did this, just needs to revisit this whole system.
My lady, the document is the affidavit that was filed, and in particular, if her ladyship could go to page 11 of that document.
Is it what's the document number?
011.
Just 011.
Yes.
I got 011.
At page 11, yeah. 011, then page 11 thereof. So it will be 011-11.
Yeah, but that's your heads of argument, isn't it?
No, my lady, it's wrongfully. It's supposed to be applicant's supplementary affidavit, but if her ladyship could go to page 11 of that document.
11.
011-11.
Yes, and that's part of your.
And her ladyship will see there at the prayer that wherefore the first and second applicants pray for the following orders, that the supplementary affidavit be accepted by the court, and as such the admittance of the forensic auditor's report dated 31 August 2022.
Oh, no, Mr. Mokonoto, you're not getting away with it so easily. This is your head of argument. This is not an application. By any imagination, it is not an application.
My lady, I have got my heads. My heads are under, if I could assist the court, just one moment. They are under bundle 0291.
Oh, no, my
so this document, if I may assist her ladyship, this document is titled Applicant's Heads of Argument.
That's what I have.
But what it actually is, it's the applicant's supplementary affidavit, which is, it starts on that page, I, the undersigned. Now, heads of arguments cannot be under oath. So it was an error committed by ourselves, my lady. It is actually, that document is actually went with the application for what do you call this, for the supplementary affidavit to be accepted. Now, the application has been made, and the application specifically also asks that the supplementary affidavit be accepted. And my lady, if I could also take you to the court order again. The court order had said that we should file this by the 7th, which we did, and that the respondent then had to answer. My lady, with respect, there has been no answer from the respondents. So on record and on paper, there is no opposition to the filing of the supplementary affidavit.
My lady, if I may be permitted, you see, my colleague wants us to accept that a prayer in its supplementary affidavit is essentially an application for condonation, for permission to file a supplementary affidavit. There ought to be a substantive application that ought to have been dealt with. That's what I was waiting for. And in the absence of that specific document, I cannot be called upon to then respond to a supplementary affidavit, which is an irregular step considering a directive of the Honorable Court. So my colleague is not pointing the Honorable Court to an application. He's merely pointing the Honorable Court to a prayer in its supplementary affidavit, which says that the supplementary affidavit ought to be incorporated into the main application so that it reads as one application. But it does not point, Your Ladyship, to the application that says, if my colleague could be so kind and to say to the Honorable Court, if this Honorable Court attention could be drawn to paragraph, to page so and so, where we deal with the actual application for, what do you call this thing, for permission to file a supplementary affidavit. They have not done that application, my Ladyship, and cannot be accepted. This court cannot be expected to then go and deal with the supplementary affidavit when there's no permission for that supplementary affidavit to be filed.
Okay,
if my colleague could refer us to the application, which is clear, the order is clear, file a request to file a supplementary affidavit. Where is that request? And it cannot be in one document. You cannot file a supplementary affidavit that encompasses a request to file a supplementary affidavit. I've never seen it being done that way, my lady.
Yes, I quite agree. I mean, firstly, the carelessness in entitling this document applicant's heads of argument, because that didn't really make sense to me, and I didn't know what on earth was going on here. And secondly, you can't simply file an affidavit unless you bring the application to court. And this, in effect, is what you're doing, is incorporating the contents of your supplementary affidavit, Mr. Mokonoto, and then you're asking for leave to file it in. That's not the way it's done. I don't know where this system, but in KZN, it's not done like that. I can't hear you. You are muted, Mr. Mokonoto.
Lady, apologies, my lady. What we had sought was the admittance of a forensic auditor's report.
Let's deal with this in a practical way. I had to read the whole thing. So, which means that I've got an idea of what's in that forensic report. The whole issue of that forensic report, only to the extent that it deals with the amounts I'm just going to ask you, Mr. Matlangu, and I'm not giving a prima facie view of what I think or what, just to try and get this matter resolved without all these further interruptions. And this is what I want to put to you, and you can disagree, and then we can take it from there. If the forensic report is only to the extent that it decreases the amount claimed, Mr. Matlangu, isn't that in the interest of your client?
I do not follow, my lady. If the court could be so kind as to just toddle along with me so that I follow the court fully.
What I understand the forensic report is that it will clarify the amounts that have been claimed, and I think from what was stated will reduce the, is that right, Mr. Mokonoto?
That is correct, my lady.
So it will reduce the claim that your client will ultimately face. And I'm just wondering if that is not in the interest of your client ultimately.
No, it is not, my lady. The reasons for that is that the process flow, insofar as the computation of these claims, the investigation conducted by the first applicant, that ought to have, there are issues with that. So any submissions to this honorable court that seeks to decrease or increase the claim amount ought to be dealt with fully by both parties, meaning therefore that I ought to be afforded an opportunity to then say my piece insofar as that report is concerned, that forensic report is concerned. For instance, I've had no sight of this forensic report. I wouldn't want to comment whether it assists or does not assist my client.
I hear you.
Yes.
Right. So basically it's an application for leave to file, which I don't have.
That's the issue, my lady.
Mr. Mokonoto, I think the best course of action would be now to bring the application properly motivated before. You can't simply hand in the affidavit indirectly. You've got to bring the application formally.
My lady, what I was endeavoring to put forth to her ladyship is that what we had sought was the submittance of the forensic auditor's report. And to demonstrate,
he has the right to challenge that. They might have an expert who challenges the manner of its computation, and I think that's what Mr. Matlangu is saying. You're closing the door to all of that by simply indirectly and indiscreetly simply handing in this report and then bringing your application. It's not done like that, Mr. Mokonoto. It is certainly not done like that.
And that is precisely why, in terms of the order that was made by your sister Mudiba, the respondents had an opportunity to react to this.
To react to anything, because there was nothing for them to react to. They only had to react if you brought the application. You brought no such application.
My lady, the only, and I will refer this court to her ladyship to the matter of Ndlebe, wherein it is clearly illustrated that the filing of a supplementary affidavit, in the filing of supplementary affidavits, the court must endeavor to deal with the real issues between the parties. Now here, the real issue between the parties is as to whether when it will be just for the applicant to claim.
Mr. Mokonoto, I think you're missing the point Mr. Matlangu was trying to make. And I think it's a valid point. And it's this. It's that you are indirectly, well, you put up what you would call an expert report, and the report by an accountant who is an expert in accountancy. They have a right to challenge that report. But the problem is you haven't even brought the application to file that report properly. You haven't even got out of the starting block. You simply filed the report. They have nothing to answer because you put the cart before the horse.
No, my lady, I have filed an affidavit which confirms that what it seeks is that this affidavit be accepted so that the forensic auditor's report will be then admitted. And that, my lady, is at page 011 of 011-11. It clearly states there that the supplementary affidavit be accepted by the court, and as such, that the forensic auditor's report dated 31 August 2022 be admitted.
My
So
lady,
what we
if I
seek
may.
here is the admittance of what we seek, my lady, with respect, is the admittance of the forensic auditor's report. And the respondent would have then had an opportunity to react to that. And in the event they seek to file, to use their own expert, they had an opportunity to do so almost a month later on the 21st of October 2022, which they did not do, my lady.
My lady, if I may, Mr. Mukonoto wants to deliberately ignore the one simple fact, that is the one simple impediment standing in front of him, which is there an application, is there a formal application, a substantive application seeking permission for you to file that which we are arguing now? You see, we are not saying that we are not going to deal with the supplementary asset. And the case that he cites, it's a case where permission, or there was then the authority or the leave to file the supplementary affidavit. So he raises a case law that does not assist his case. But the issue is, did he obtain permission from this court to file the supplementary affidavit? And the answer to that is a resounding no. There is no permission for him to do that because he has never requested the permission to do that. And you cannot now go to the supplementary affidavit and say, on the strength of the supplementary affidavit, or what the supplementary affidavit says, please accept my supplementary affidavit. We don't do things that way. At least from where I'm from, we don't do things that way. You ought to have moved a formal application that says, I'm seeking leave to file a supplementary affidavit. These are my reasons why I want to file a supplementary. And he'll go to town about this accountant and this report. And I will be given an opportunity to then respond in line with the directive, with the court order. Now, what they have done, they've specifically defied a court order and want this honorable court then to accept that defiance and assist them in pursuing that defiance, my lady. And that cannot be. That's not how these courts operate.
Yes, Mr. Mokonoto, I am not going to entertain this. Because
my lady, with respect, if I may just be given one moment.
Oh, you listen to me now. You're
okay, my lady.
And I am not going to allow that. You listen to me.
Please, my lady.
I will give you an opportunity to talk, but listen to me.
Please, my lady.
The way we do things, we don't do things in this manner. The direction by the court was you bring an application to file a supplementary affidavit. You didn't bring it. You simply brought you put a sworn affidavit, and then in the affidavit incorporated the whole contents of the report. And then in the last two lines, you say you ask for it to be incorporated. Where on earth does that happen? It doesn't happen that way. I think I'm not going to deal with this any further. I think you should bring this application properly, because in your application you've got to motivate why you didn't bring it in the first place. Why, when the investigators were dealing with this application, why didn't they then seek the accountant's report at that stage? You got to put up those reasons first. I got to look at those reasons and see why is this delay in why you have to now furnish this report at this late stage. And then I've got to decide, maybe, in the interest of justice or whatever the reason, I will grant it in any event because there's no prejudice or whatever the case might be. And that is how it's done. But it's not the way it's done. I'm sorry, it can't go on. We're wasting our time, Mr. Mokonoto. We can argue this from now till doomsday, but the problem is you have not brought this in the proper format. And we can't condone these lapses. If we do that, then, there's no order in these courts, really.
Please, my lady.
Okay, so what do you propose doing? Adjourning this matter, bringing your application, formal application for...
As the court, please, my lady.
Okay, Mr. Mahlangu.
I will ask that be the bonus.
Do I need to give you a date to bring this formal application by?
I did not get the first part of your lady's submission of a lady's directive. The first portion when the
well, I think you should bring it as soon as possible so that this matter can then proceed. Can you give me some dates then, Mr. Mokonoto?
My lady, can this be by within 7 days, by next week this time, my lady? Today is the 1st, so it should be 8 March.
Okay. Directions will be formal application, so I'm going to make this very clear. It's just one. And when shall the respondents be required to file to answer the request?
21 March.
If it's 8 March for the filing of the amendment, then it will be at least, 14 days thereafter.
Exactly, my lady. It's
21 so 14
March.
Will be 22. Is that a week? Is that
yes, 22, my lady, 22.
And then, did you file a replying affidavit?
Yes, my lady, we did.
My lady, I beg your pardon, my lady.
Did you file your reply affidavit?
Or reply, ma'am.
I can't hear you, my lady.
Did you file your replying affidavit in this matter?
Yes, we did, my lady.
So will there be a supplementary replying affidavit once the
if the court so allows, my lady? I think it will be best that we do.
Okay.
A further 2 weeks, my lady. I'm taking cue from the court order that was made on the 4th. So a further 2 weeks should be somewhere for November. So it should be 5 April.
Okay. All right. Okay, then this is Matt Sine Day, is it?
As the court please, my lady.
Oh, is there a date? I think it is.
My lady, may I request that it be set to a date and that both the application, okay, Synergy, my lady, I think Synergy.
At this point in time, I don't think all of us have our rosters, so we have no idea where we can put it in. But I'm happy to keep the matter here in KZN and deal with it because I've read the papers and it wouldn't be fair to another judge to take over now. So may I just ask from Ms. Simpson, if she's there?
My lady, I'm struggling to hear you, my lady. There should be a slight disconnect. So your leadership is not coming through quite clearly.
Ms. Impo, are you there?
I'm here, my lady. Yes, Judge,
okay.
I'm here.
I will keep these matters and I'll deal with them when eventually it's all finalized. Do you have any dates in mind to adjourn the proceedings to, or would you suggest we just adjourn it sine die for now and then
I do have dates in mind, Judge.
I think Sajala is also online.
Yes, so Sajala can also assist me in April or June.
Yeah.
The second.
Okay, Sajala.
Let's just assist me. I have the first week of June when we can. I know we can accommodate then.
Okay, just ask Sujala.
If Sajala has anything for you, then.
She online. Sujala online.
She is. I'm not sure where she is. Yeah.
Sujala, I'm not sure where she is. I'll have to call her.
Judge, I just spoke to Sajala. She's saying that you have got hurt in June.
Okay, and what about May?
And so in May, I'll let you know now because I know that there are matters that have been allocated to you. I'll just give you dates now.
Some judge is not available
From the 15th of May.
Yes.
The
8th of May, June, Judge.
Is that okay, Sarah?
Yes, 8th of May.
Is that in my tribunal section?
Judge?
Is that my tribunal section?
I'm struggling to hear you, my lady.
Okay, is that in my tribunal
I
section?
think there is a background noise. I'm not sure where is it coming from.
Somebody's got a phone or something on.
I can hear you now, Judge. You were saying?
Is that from my tribunal session?
Yes. We can accommodate this matter on the 8th of May.
So then it will be, I think it will be the same order for both the matters then, it would appear. Am I right? Oh, well, the other advocate needs to come on board, yeah.
I think the matters are
My lady,
different.
Might I come in?
Yes, Mr. Moratiwe.
My submission is that my matter is different from this one.
Okay, all right. Thank you. All right, so in the matter 04, let me just, last week. Okay. The matter of SIU versus MP2 Trading case number NW04 2022. The matter is adjourned for hearing to the 8th of May by March. The applicants shall seek leave to file their supplementary affidavit, seek leave a formal application, and the respondents shall answer to that request by the 22nd of March, and then the applicants shall file any supplementary reply to that answer by the 5th of April. I'm going to reserve the issue of costs for today, for hearing on the 8th of May.
As the court, please, my lady.
Thank you. I'll excuse you, Mr. Moro.
Please, my lady.
Please check the.
Somebody has got something on. The background noise.
It's from Mr. Matlangu, my lady. I think he's dealing with that now.
Okay. All right, let's proceed with this application.
As the court pleases, my lady, I confirm my appearance on behalf of the applicant in this matter.
Should please your ladyship, I appear for the respondents, the first, second, and third respondents, my lady.
Okay. Right, Mr. Moratiwe, how is this different?
My lady, this matter is different because the affidavit, the supplementary affidavit that was filed in August last year. And in October, a case manager.
Is there a formal application to bring this?
No, my lady.
Well, then you're back to square one, aren't you?
No, my lady.
Why?
I will explain.
Okay.
Yes, my lady. And then a case management meeting was held in October.
Okay.
In that case management meeting, the SIU made it clear that it intends to file a supplementary affidavit.
I think you've got it wrong there. You can't simply intend to file a supplementary. Was that agreed to by all the parties?
No, it was not agreed, my lady. I'm still explaining, my lady. I will be very brief.
Sure.
Yes. And then the court gave directives as to what should happen, the filing of affidavits. The SIU then filed a supplementary affidavit. In that affidavit, seeking leave to be that the matter be that affidavit be filed with leave of the court. The matter was then in court. When the matter came in court, Justice Mudiba made an order that the respondents are to file their answer to the supplementary, if they so wish, on a specific date. They have not done so. We say they cannot hold the court at ransom. They cannot come here now and say, an affidavit has been filed without leave, we don't know what to do. They have had more than 6 months to deal with that affidavit. They cannot come and tell this court when they have been ordered to file. It is different because here there is a court order directing them to file if they so wish.
You know, the way I understand the issue of supplementary affidavits, or the way I've learned, Mr. Moratiwe, is that where you've not brought an application or your application is insufficient and you bring an application to file a supplementary, you simply don't ask the court, tell the court, I'm going to file a supplementary. You have to bring a formal application to file a supplementary wherein you say to the court, I seek an indulgence from the court. And these are the reasons why I seek an indulgence from the court. And you set it out. You don't simply file your supplementary affidavit and then say, well, I filed it now, and therefore the judge said you must respond if you wish to. You haven't. Have you brought the formal application, and did the judge say to you, right, you're allowed to file your supplementary? Is that what happened? If that is what happened, then of course you're correct.
My lady, the affidavit is not yet admitted before the court, but there is a court order directing the respondents to deal with that.
But how can that be?
My lady, yes, my lady, I must state that I disagree with your ladyship's views with respect on the filing of further affidavits. I have raised this particular argument that my learned colleague is raising in a different matter. And I'm trying to find that judgment now. Where in that matter, I raised the very same argument. The court said no. In the absence of any prejudice, that affidavit was permitted by the court. I will find that judgment, my lady. If your ladyship can just give me a few minutes to stand this matter down, I will find that judgment where this issue was dealt with.
There was no formal application to bring that affidavit.
There was no formal application, my lady.
The affidavit was simply handed in, and the court said it's fine. Correct,
my lady.
Well, I don't know. I might differ with that judge.
Yes, my lady. And while because what regulates the filing of further affidavits? Normally, it's 3 affidavits, my lady. Rule 65E deals with that. It says the court may, in its discretion, permit the filing of further affidavits. It does not require a formal application. It simply says the court may permit in its discretion. There is no requirement of a formal application.
But in this case, you know, in this case, that application to file is opposed. The other party is opposing it. Then you've got to bring a formal application.
Yes, my lady. My lady, the matter just stand down so that I can provide the court with the judgment that I'm seeking.
My lady, before the matter stand down, if I may, with your leave, with your permission, because I think my colleague is taking us astray. The judgment does not speak.
Hold on. I want to look at Judge Modiba's practice directive. Can you direct me to the page? I mean, her directions, please. The directions.
My lady, your ladyship will find them. I'm on case lines, and I hope I'm on the correct document. It's 076.1, and it's dated 12 August 2022. I don't know if that's the correct document, my lady. However, that document does not deal with the supplementary affidavit. It deals with the reply. And the reason why it deals with the reply and the answering affidavit is because what it transpired is that prior to us being given access to case lines, so we would file ordinary, because the matters commenced in Mafikeng. So we'd file our answering affidavits at the local state attorney's office in Mafikeng. So they were never uploaded onto case lines. So what your ladyship, your sister advocate, Judge Mateke by Judge Mudiba had pronounced on was not the supplementary affidavit. It was the answering and replying affidavit. And I will read the specific portions, and if you find it in paragraph 3.7. But it says, the Honorable Justice, I beg the ladyship's pardon, on case lines on 076.3 and paragraph 3.5, 3.6, and specifically paragraph 3.7, my lady.
You know, this numbering it's really got to me. Honestly, I cannot follow this numbering. Okay, I need to see that order, but I don't know where to find it in this huge file because there's no proper numbering. Is this the one for the 12th of August?
That's the only one I have. I don't know if there's another one.
Okay, then I managed to find it. It says here, Advocate Morativa stated that this matter is one of the matters before the tribunal. The matter is unopposed, as the respondents only filed a notice to oppose but never filed answering affidavit. He stated that the SIU has appointed forensic accountants to quantify the SIU's claim, and as a result, the SIU will file a supplementary affidavit dealing with the outcome of the forensic investigation relating to the quantum. The Honorable Justice cautioned that the parties must be careful not to refer to other matters because they have not been consolidated. Mr. Mashlangu stated that the respondents did file answering affidavit on 8th at the office. Okay. In response, stated that the report to be filed by the forensic will assist the tribunal by placing all relevant facts. To the extent that it is necessary, the SIU will seek leave of the court to file the supplementary affidavit. The Honorable Justice Modiba raised a concern that this matter has been dormant since 2020 and that the case management was initiated by the tribunal. Had the tribunal not initiated, the matter would still be dormant. On that premise, the Honorable Justice directed that the matter must be placed on the roll. Advocate Moratiwe indicated that since SIU has not seen the answering affidavit, it would be necessary to factor in the filing of a replying affidavit in the timeline. The Honorable Justice made the following directives: the respondents to upload, the SIU to file a replying affidavit, the SIU to file its heads, the respondents to file their heads, the SIU to file and upload paginated, the matter to be. There is absolutely nothing by Judge Modiba about not bringing an application to file a supplementary affidavit. There is absolutely nothing on her part.
My lady, might I come in? My lady, when you read paragraph 3.76 of the very minute that your ladyship is reading,
yeah,
it says the matter is going to be heard on the 4th of October. My learned colleague is not addressing you on what happened on the 4th of October. On the 4th of October, it is when the court ordered, it was not a directive because it was an order. The court ordered that the respondent shall file its answer to the supplementary affidavit. My lady, unfortunately, that court order has not been uploaded.
Mr. Moratiwe, then you are at an advantage. I do not have that. Is that on what date was that?
On the 4th of October, my learned colleague appeared. He can confirm that.
Okay, can you read that out to me, because it may be here, but I can't get my hands on it.
My lady, if I may be permitted, the filing of the supplementary papers, this argument about the leave to file supplementary papers was advanced by my colleague on that day, and he will agree with me, and that request was rejected. So I do not understand why. Maybe perhaps what would help this honorable court is if the order of the 4th of October, so that we do not speak across each other. The order of the 4th of October be placed, and it ought to have been placed in file by the applicants, this being their matter and all. That on the 4th of October, the respondents were directed to do this and the other, and they failed to do so. And then this will take us further to want to introduce decisions of other cases where we were not party to it, do not know what the arguments were advanced there, is neither here nor there. We won't take this matter closer to Christmas. All I'm saying is, let's find the court order of the 4th of October. It be placed before your ladyship. The ladyship then can see what her sister Justice Modiba had spoken about and what was the orders on that day. And it ought to be in file. If it's not in file, then the applicants ought to then say, why is it not in file? Because this is their file essentially. Court pleases, my lady.
I can't see it here. Perhaps they can direct me to where it is. Mr. Moratiwe, direct me to what page reference or whatever it is, because your system, of pagination is completely, I don't know. It's.
My lady, I indicated that the court order is not uploaded. It is not there, my lady. But it is there. That is why I'm saying my colleague was there. I can read it out because I prepared the draft order in that matter. I specifically prepared the
order that was signed by Judge Modiba. What you prepared and what Judge Modiba signs is maybe two different things.
Indeed, my lady.
That is signed by Judge Modiba. Her signature must appear on that order.
My lady, my colleague and I were there, and we can confirm what the court ordered.
Okay, but he differs from you.
My lady, the court ordered that the matter is postponed to March 2023.
Yes.
The respondents shall file an answer to the applicant's supplementary affidavit on or before 21 October 2022. The third order, the applicant shall file its replying on or before 4 November 2022. 4, the applicant shall file its heads of argument on or before 11 November 2022. 5, the respondents shall file their heads of argument on or before 18 October 2022. 6, each party to pay its own costs. My learned colleague can confirm that he was there.
Okay, Mr. Mahlangu, do you confirm that order?
Well, my lady, until such time I have signed, of the order signed by Judge Mudiba, because I remember specifically my colleague was taken to task by Judge Mudiba when that transpired on that day, and I would be comfortable if a signed order was placed before. You can send this matter down, the order be located, it be placed before your ladyship, and then we proceed. My colleague wanted to send this matter down either way. And I remember there was a draft that was sent through by Mayor Mashitisho, Mpho Mashitisho. I'm just trying to find that very draft, because I think that was the one that we were sent through to say to confirm or not confirm. There should be a draft from Mayor Mashitisho's emails. I'm just trying to locate it, my lady. I can't find it from my emails, but I know that she sent a draft.
Mr. Mahlangu, this is what I see. It's one of two things. Either you are correct or you're incorrect. If you are incorrect and Mr. Moratiwe is correct, then it simply means that Judge Modiba has allowed the filing of that further affidavit, and then you fail to respond. If it's incorrect, then we have a different situation. Then it means there's been no formal filing of that affidavit with the leave of the court. That's how I understand it. So I think Ms. Mpho can assist us by perhaps just emailing me quickly that document. Mr. Moratiwe, if you were relying on this document, why is it not in my papers? Because you're the applicant in this matter.
Yes, my lady, I actually inquired with my attorneys yesterday as to why it was not there, but it appears that it was an oversight on their part.
And that is important. I mean, because, you know, it changes the focus of my whole understanding of what the application is. And, you know,
Indeed,
that's
my lady,
relevant to my preparation. And if you don't put, you know this, Mr. Moratiwe, you know, really, my mind boggles at the way things are being done these days.
I understand, my lady, and I apologize for the inconvenience caused to the court.
Can somebody assist us now with that document? Because there's clearly a dispute about what is in that document.
My lady, my learned colleague was trying to locate it. My understanding was that he was trying to check if what Ms. Mashitisho sent to him is exactly that. I'm not sure if he's still looking for that.
I've gone through that. What I have is, it was actually from Ms. Zondi. I think it's Ms. Stella Zondi to both myself and Ms. Mashitisho. So it will be the order that my colleague is reading from. So it is email from Ms. Zondi. The email is dated, here it is. The email is dated 7 October 2022. It was sent at 11:16 from Ms. Zondi's email to both myself and Ms. Mashitisho. But there should be an order. So it's what counsel is speaking about, the one that he says, the one that counsel is reading from. However, I remember that the order was, we departed from this order very markedly. So there should be an order from Justice Mudiba that then deals specifically with the issues that we are seized with now, my lady.
Okay.
And I believe it will be in the court file, somewhere in the court file.
Okay, Ms. Mpho, I saw her flashing. Can you assist us, please?
Judge, the order is not on case lines, so I don't have the order. So I'm not sure if it was ever signed or not. So perhaps they can help us if, did I ever send a signed order or not? Advocate Morete, did I ever send a signed order? Is the order that you have signed?
No, I do not have a signed order.
Mr. Matal?
Neither do I, Mempo. I do not have a signed order. The last order I have, that it's for a different matter. It's not for this matter. It's matter number 02. It's not number 03.
All right, then I suggest this, because there's obviously a dispute as to what really happened. Either you get a transcript of the proceedings on that day, and then we take it from there. We adjourn it until you provide me with a transcript, because we can't deal with this matter one way or the other, because you have different views of what really happened, and I can't make a ruling until I know what the judge directed on that day. Okay, so
My lady, I understand the court's predicament, but legal representatives are here to assist the court.
Yes.
My learned colleague and I were here. A court order was sent to him, a draft order was sent to him. If he had any issues with the draft order, he should have notified us and the tribunal. He did not do that.
Okay, perhaps he can explain that.
My lady, my colleague wants to suggest that I'm deliberately misleading this honorable court in not so many ways, but that's what he's implying. And the only way to debunk or to confirm what he's saying is what the relationship directs, that we get a transcript that says this is what transpired on the day.
No, but he's made a
and
good
remember,
point.
my lady, remember, my lady, what transpired on the day, and the order that ought to have come to me is an order that comes from Ms. Mashitisho and not from the, and it was not for me to confirm. It was an order that was meant to go to the judge and not to me, because it was not intended for me. I do not sign orders, my lady. So if a draft order were to be sent, it ought to have been sent to Mayor Mashitisho for the attention of the judge. For me to have been sent for information purposes, not for me to comment, because the email does not even say anything. It just says, please find order. However, my lady, the matter would be resolved very quickly and very seamlessly if the record of the day was to be placed before this honorable court, before your ladyship, as it were, to say that this is what transpired, these are the arguments that were advanced. And I remember, my lady, and I do not want to take this court back. I remember the issue of how you proceed to file supplementary affidavit came about. And I remember there was an issue about filing an application in terms of this and the other rules for you to be given permission to file the supplementary affidavit. And the issue was, because you have not signed that supplementary affidavit, then that supplementary affidavit cannot be accepted. I remember I remember my colleague and the judge had that engagement at length on the day, my lady. However, I'm saying if I'm incorrect and my colleague is correct, then Justice Modiba's order would then, rather the transcript of that record or the order itself, will then clarify the issues, my lady. Because I do not wake up in the morning and want to mislead this honorable court. I'm an officer of this honorable court, and I'm not one to mislead this honorable court.
Mr. Mahlangu, then the point is this. When you received that alleged recordal of the proceedings, why did you not challenge it as being incorrect?
You must remember, my lady, it was sent before we appeared, I believe. It was not on I don't think it was sent after we appeared. I stand to be corrected. To me, it arrived on the 7th of what you call this thing? On the 7th of
So before the directions hearing.
Before remember the directive hearings were made in August, but that dealt with a different issue. It dealt with that my colleague has not had sight of our answer.
Order. All right.
Yeah.
Okay. I think
my lady,
may I advise? I got the transcript, and it seems that Advocate Morella is correct. I will just send the transcript from MS Teams to the advocates so that they can also see it. So the order is what the order was granted. So what was Advocate Mahlangu supposed to do was to confirm that that is the draft order, and we would have signed it. So that is the only reason why the order is not signed. However, that is the order that was given by Judge Modiba on that day.
My lady, might I just make this one comment? I don't want my colleague to misunderstand me, because he seems to have been offended by my submissions. I do not in any way insinuate that he's misleading this court.
Well, what worries me is that you are both at this one hearing and you both have completely different views of that hearing, and that concerns me. I'm waiting for this to come through. Are you emailing it to me, Mpo?
Yes, Judge. I will email you. It's a transcript that MS Teams transcribe as we are having discussions now. So you will just go further down. It comes in a MS Word document. So you'll just go further down. You'll see the order as it was granted by Judge Modiba.
I'm very technologically challenged here. How do I go to this thing? Where on earth? Gallery. No. Oh Lord, I've lost. Oh man. Okay, where can I see this? Can you Mr. Mahlangu, if you can see it and confirm that what Mr. Moratiwa had read out was correct, then we can move forward. I cannot see. I'm not sure how to even get access
I'm
to
trying
it.
I'm trying to get to the exact portion where uploaded documents would appear, my lady. If Lematshe
So
could assist.
I
I
have
have show device settings, show meeting details, enter full screen gallery, large gallery together mode, show background effects, turn on live captions. So I don't know where I would.
I have downloaded the transcript, so I will be sending it to you now, Mr. Mahlangu and Ms. Zondi. It will come to your
It
email.
will appear on the Teams or somewhere
Yeah,
else.
you wouldn't have it because I'm the one that transcribed.
got it right here. She sent it to me. Yes, she's granted leave to file the supplementary. Judge Modiba has granted leave. She says, I will grant the something SAU leave to file, and then underneath the supplementary, and then underneath founding affidavit, and then the respondent must answer to it, and then only will the applicant file its reply.
Of course, please, my lady. Thank you for that. May I extend my apologies to my colleague on the advocate Mungwe. It appears that he was correct, my lady. Am I audible, my lady?
Yes, I'm just trying to read further. Yes, it's not exactly clear what really happened, but I seem to get the at some stage what was contemplated by the parties that the SIU will seek leave to apply to file a supplementary affidavit. Repeated indulgence to file that report, so I actually didn't trust that it was going to be found.
My lady, might I make a submission?
It's really not very clear.
My lady, might I propose a solution?
Yes. Yes.
My lady, I would caution to simply rely on a transcription from MS Teams, because it would not have a transcriber certificate, and we might have issues in case this matter maybe goes on appeal or anything like that. So I think a sensible solution is that this transcript be properly transcribed, and then if it is correct that the order is as it is, then the parties will file heads of argument before the 8th of May, and the matter be heard together with the other one on the 8th of May. I think that will be a more sensible approach, my lady. I do not, my submission.
If you're looking at this transcript, I'm not, there's like discussions, and then I don't know what the reference is to, and I'm battling to understand this. It says, this one, like, you'd like to oppose the filing of that affidavit. And then it says, deal with it in your supplementary answering affidavit. Deal with that opposition. But I advise you to plead it over in case I grant them lead. Or I'm not sure what is being said there. I think it's not being translated correctly, So it's so difficult when the order is not signed. Okay, let's adjourn it to the 8th of May then, this matter as well. And then use the same dates. File the transcript, proper transcript of the hearing by the 8th. And I think, I'm not sure if one should, because there is no order, maybe the parties can go to Judge Modiba and get clarification on what was really agreed on in that transcript, because I can't seem to make out.
My lady, I think just the court order will deal with everything, because a court order, my lady, stands up until it has been set aside. So once we get a signed court order, that will end everything.
So when do you propose to get the signed court order?
My lady, I will engage my attorney to get it as soon as possible, before in a week's time, my lady.
So give me dates. So just to obtain the court order, and then the matter is adjourned to 8th May, and then the parties can then by the 8th May bring whatever applications you have to bring.
Yes, my lady. The court order shall be uploaded by latest the 10th of March.
Okay, this is what I propose doing. Matters adjourned to 8th of May for a hearing of the application. By then, the parties must resolve the issue about the supplementary affidavit by filing a signed court order by the 10th of March. And the costs of today are reserved. Okay. Thank
my lady,
you.
might I, sorry, my lady, just the first order so that I can prepare a draft and send it to your ladyship for signature.
Adjourned to 8th May for hearing, the formal hearing of this application.
Yes, my lady. And then two,
that the signed court order must be filed by the 10th of March.
My lady, Advocate Moret, I don't know whether you can hear me, but I can't hear anything. Since from the last time you made your proposal, I have not heard anything. I've been trying to signal that I don't have audio.
I can hear you.
I don't have, yeah.
Can you hear me?
Can you hear me, Mr. Mahlangu? Can you hear me? I think Mr. Mahlangu, maybe you muted. No, you can't be. I can hear you. Your sound. Maybe there's something wrong with your sound. Can you hear us? My lady,
I have sight, I have visual, but I don't have audio. But I have visual. Sure. I don't know whether you can hear me.
I can hear you.
Yes.
I can hear you.
The only thing,
I can hear you.
I'm trying to find maybe a set of headphones that would help. If you could just bear with me for 30 seconds, my lady.
Okay. Can you hear us now? Can you hear us now? Mr. Mahlangu, can you hear us now? Can you? Can you hear us now? Sure. I think you need to connect. Oh gosh, how do we tell him this now? Ah. Mr. Mahlangu?
Can I just be permitted to disconnect and reconnect the whole?
Yes. Yes.
I'm getting bits and pieces, my lady. It's coming back, but it's...
Okay.
Yeah, I got it.
Okay, you can hear us now. All right.
Yes, ma'am.
What I propose that the matter be adjourned to the 8th of May for the formal hearing of this matter. That the signed court order be filed by the 10th of March, on or before the 10th of March. Depending on what the court order says, all issues relating to the application for leave to file a supplementary affidavit must be resolved before the 8th of May. If it means following a similar procedure to that was directed in the previous matter, the 04 matter, then follow the same dates. If not, then I think the respondent has to then respond to the affidavit. Is that clear, Mr. Morris?
The third order is a bit lengthy. So what I have captured is depending on the court order.
What was directed?
All issues relating to the filing of affidavits should be resolved
before the 8th of May.
Yes.
Because that is when the formal hearing will be. And then if the court order was that the supplementary affidavit, or if the court had accepted the supplementary affidavit, then the respondent is directed to deal with it by further affidavit. All these issues have to be resolved before the 8th of May.
Indeed, my lady.
Yes, court, please, my lady.
If the order was not what the applicant is indicating, then we follow the similar date lines that I corrected in the previous matter, the 04 matter, and I think that is on record already, that order.
My lady, I would not have had the benefit of those dates.
Okay.
If I may,
you can get those dates from Ms. Mpo from my order. Let me just see if I can recall them.
if I may assist, the 8th of March was for the actual request for the filing of the supplementary papers.
Yes, it was the amendment. The application for the filing was the 8th of May.
Then on the 22nd would have been the response, which is the answer. Then the 5th of April would have been the reply, if any.
Yeah, chapter 3 reply.
The 5th of April. Yes.
Yeah. Okay. We got those dates then.
As the court pleases, my lady.
I think once you put this down in writing, I can correct it, do whatever, but just put that, encapsulate it into an order, and then I will sign it and make corrections if necessary, and then you have it. Okay. The meetings are then adjourned to 8th May, and I've reserved the issue of today's costs. Thank you.
My lady.
Thank you.
As the court pleases.